to start. So, Your Excellence, distinguished colleagues and professor, as a chairman of the IP Commission of the Milan Bar and on the Milan Bar, Mr. Antonino Lalumia, I would like to welcome you all to our wonderful city. As you probably know, our city has a great history at the center of Europe, going back to my lineage, all the way back to Emperor Diocletian, and has always been in the centuries and at the middle of commerce and finance, also for its geographic location. Therefore, we are very sensitive to the topics of today's event. And this is the reason why in 2023 has been set up the IP Antitrust Commission of the Milan Bar, with a specific task of facilitating and fostering the training of lawyers in the field of industrial property, competition, and antitrust law. Professor Rossi Dal Pozzo is a very active and key member of the Commission, and I would like to thank him personally for the passion and professionalism with which he tackles the issues of industrial property and competition law on a broad scale. I would like also to thank Mr. Calzorari and Mr. Croci for the organization. Hopefully, it will be possible to organize other sessions like the current one, since a continuous dialogue between all the categories of judges, university, and lawyers is helpful and positive. And so I wish you a successful conference, and I think I give the floor to Mr. Munari or Mr. Assi. I apologize, I cannot stay for the conference because I have a flight, and really I apologize, but you know, that's it, I'm sorry.
Thank you, Cristiano. Thank you to the Bar Association of Lawyers of Milan that host us for this conference, and thank you to the wonderful organization of this conference. That it's also an opportunity for us to meet again some friends. As Yanni Simplis, we work for a number of years in the Association of Competition Law Judges. I was asked unworthy to replace Adam Scott in leading the group of the first session at the last minute. Sorry for that. Adam unfortunately had a delay with his plane. The flight was cancelled and will arrive only in the late afternoon today. I will be a speaker for the session of tomorrow morning on private enforcement, but today, this afternoon, I have also this opportunity to be the moderator, the chairperson of the first session. I worked with Adam for a long period in the Competition Judges Association, created with a group of European judges, if I remember, on 2002 or 2001. Thank you. I correct my speech. 2001. And I was among the founding members and was its president for 2 years until March 2021. Adam is the general secretary of the soul of this, and he is also the soul of the association and continues to enliven it. The association is the interlocutor of the European Commission for the drafting of new law and for discussions of the most important issues at the moment. I remember that we were also consulted for the drafting of the 2 regulations we are talking about today. I don't want to waste any more time on the reports of our brilliant speakers, which are certainly more interesting than my word, and which get to the heart of the theme of this conference. I have to introduce to you the first speaker, Professor Francesco Munari. Sorry, I cannot read all your CV, but Francesco Munari is a tenured professor at European law at the University of Genoa, where he teaches also maritime law and transnational law of the environment. He is partner of Deloitte Legal, head of practice in international and European law. His practice comprises European and international law, antitrust, regulated markets, and so on. A lot of important tasks. He is also member of the board of many think tanks on transport and maritime matters. It is also co-director of the journal Diritto del Commercio Internazionale, Diritto dell'Unione Europea, Diritto Marittimo, and author of several essays, books, and shorter articles on the above-mentioned topic. Francesco Munari will introduce you the general term on competition on digital markets and a general introduction. Please, Francesco, the floor is yours.
Thank you, Mrs. President. I thank the organizer of this conference and for inviting me to this very interesting roundtable or symposium. I think I have 20 minutes or so. This is exactly what I was told about. So I will try to make an introduction on a very, let's say, interesting and an important topic in competition law. Because if we look back, less than 10 years ago, actually, the first works on digital markets and competition appeared in the literature, and they were raising some concerns about this new sector in those years, and thinking whether, in particular, there could be an issue of algorithm competing or colluding in a way which would show the need of interpreting antitrust law in a new dimension. However, less than 10 years have passed and reality has gone much beyond the expectation, not so much for the algorithm issues, which are, however, behind the corner, since the artificial intelligence topic will certainly interfere with our discourse in the next years as well. But because these markets have evolved in a very, very dramatic way, which has then, let's say, imposed scholars, authorities, antitrust authorities throughout the world, but also courts, to think in a new way on these so-called digital markets. In fact, we have experienced the growth of dominant or super dominant firms, and I'm talking about the famous GAFAM or maybe GAMAM 5 big tech firms. And notwithstanding a significant series of public enforcement cases, private enforcement cases, especially in the US, merger control, and many other, let's say, tools that have been put in place according to the normal practice that we know about competition law, nothing has apparently changed the direction of this market, in which a few firms really become more and more powerful. They enforce, let's say, monopolistic behaviors, and still the old, let's say, tools of the antitrust law seem to be unfit for the purpose. So the idea is of my introduction is to understand whether there is really something new that we should know about that to enforce better antitrust law in this scenario, or whether there may be some other things that we should reflect upon before deciding that antitrust is fully unfit for the purpose. And I'm not saying, I want to say that for the very outset, that we are facing something which is definitely wrong from the antitrust perspective, because still, let's say, the reasoning which is normally behind any antitrust case does not always seem to fit into the cases in which we are considering the antitrust as being the most powerful, let's say, system of rules preventing market power to be abused. Let's say notions like relevant markets, like harm to consumers, consumer welfare, do not seem always to be affected by the behavior of the big techs. And therefore we should understand whether we should make other concerns, other goals for, let's say, trying to understand a phenomenon which is new, which is somehow unresting our souls, but nevertheless is there and is promising to be more and more present in our daily life. So, talking about what is a distinguishing pattern of digital markets vis-a-vis the other traditional or physical markets, scholars point out that actually there is not very much new in these markets compared to what we have been seeing in the history of antitrust. Yet, the specific feature that we are facing in the digital market scenario is that the very characteristics of these markets do, let's say, coexist altogether in the same time and with a strength which is unprecedented vis-a-vis other markets. So it is not something which is unknown to the antitrust that characterizes this market, but rather the fact that many features are always coexisting there and actually provoke unprecedented effects in terms of capability of market power growth in the hands of a few firms, changing possibilities to move to other markets with a speed which is not comparable to any other area of business, and possibility to exclude potential competitors and eventually probably to harm consumers somehow. So which are the features of these markets that actually exist in the daily digital economy? So the first one is that in digital markets, we have economies of scale, but marginal or negligible or inexistent distributional costs. So we all know that from the economic standpoint, cost decrease together with the increase of output up to a given extent, and then to expand further, the firm must invest and incurs in substantial new costs. So the cost curves, as you know, is something like that. By contrast, this is not happening in the digital markets. The firms operating in these markets actually meet no new cost, irrespective of the size of the business of their market concerned, and because it's a zero cost transaction to have 1 billion or 2 billion, let's say, consumers digiting on any Amazon or Google or whatever. For them, it's totally irrelevant. And this means, in terms of antitrust concern, that we are talking about very quickly expanding markets in terms of geography, and worldwide markets virtually that can be enormously inflated with little or no costs. The lack of distribution cost, therefore, determines that these players are actually capable of becoming worldwide in a few years, what actually has occurred. Then a second feature that we experience, which is not new, however, to digital markets, is network effects. You know that network effects characterize those markets when the value of a product, a good or a service, increases with the number of users which make use of it. This is not new. Think about the telephone. I mean, the more users are using the telephone, the more valuable is the telephone. However, in the digital markets, we have different, let's say, network direct effects. The first one is the usual one. So more users are happy when there are other users joining the same network. and the fact that the interaction in the network is beneficial for the network itself. The third feature is that the value of this network is increased with the network effect. So the owner of the network gets a lot of money and of power because of the number of users of this network. And therefore, we have this specific feature to be taken into account. Think about eBay and the fact that, of course, the more people uses this platform, the more the platform is successful and valuable. Not only direct network effects are, however, there, because we have also indirect effects that are maybe even more interesting and stronger in terms of effects on the market. The indirect network effects have to do with something which all of you probably know much better than me. So the fact that we are facing so-called two or multi-sided market structures. So we have cross-group effects depending on where is the angle in which we consider this digital market. And again, this is not new. Think about shopping malls. The more shops are in a mall, the more are beneficial, the more consumers or prospective purchasers are happy to go to this mall because they will find 100 or 200 shops. And at the same time, the sellers are happy because there will be more people visiting the mall. And this is typical for the digital market. However, in the digital economy, this phenomenon is, I would say, exponentially larger than in the physical economy, because the pace of development of this network indirect effect is absolutely larger, incomparably larger, and who is in the middle of this network, namely the owner of, now we can call it the platform, has a capability to connect an enormous variety of users in different markets. Again, developers want to be into this market because it makes them probably wealthier. Think about the apps on the iPhone, for instance. And everybody wants to be in. The user is happy because there are many apps to be there. And if you are in the middle, you can charge differently depending on where you look in terms of which is the market that you are interested for making your business. And social networks are clearly based on this system. And the issue of an online marketplace, especially in which the consumer does not pay anything, is, let's say, the very important issue to be considered, because in these zero price markets, actually the consumers is somehow not very rational in his or her decisions, because the price he's paying for the service is not paid by him or her, and therefore it's easier for the counterpart, which is the owner of the platform, to adopt, let's say, behaviors that would not be probably so innocent in other markets. This is why and we will go back to that in a few minutes. These platforms inflate continuously and grow in dimensions, not only in economies of scale, but also in the economies of scope, and making them, as it is now, I think, very persuasively argued, a sort of ecosystem. These markets are not traditional markets in the way we understand them, have become ecosystems in which the goal of the platform owner is to keep inside the consumers and the sellers in this ecosystem, because this is the best world in which they can live and in which they can make their transactions. And if this is a new notion of a market, that's probably not very easy to understand. According to traditional antitrust notions, that would be not the case because we define market differently. But the fact is that we are talking now about ecosystems, not market, as I will try to say you in a few minutes. And I know that the time is against me, but I will leave probably slides. And in any case, in a few weeks, I will have my paper ready. So I hope you will be, if you are interested, you will be reading what I'm trying to summarize in these few minutes. In these markets, there is a central issue that it is also to be considered, namely the value of data. Data are a byproduct of these markets, but data are also a powerful tool to extract value from the behaviors of the consumers. And data, I'm not quoting, there is no such thing as a free lunch. If there is no price, you are the price, all these sort of very interesting and, let's say, somehow powerful sayings according to the value of data in our digital economy. The issues that from the antitrust standpoint, are data an entry barrier to the market? Well, if you consider that plainly data are for free, are available, they are probably ubiquitous, so you can leave data whenever you like, so there is no one owner of the data. But in fact, the story may be different, because the more data you have, the more likely is your capability to profile your client and to become attractive for the sellers. And to gather a huge quantity of data is not something that you can just do from one day to the other one. It takes years. So this means that, in fact, we are facing a new notion of barrier of entry in the market because these data actually improve the quality of the platform. Think about search engines. The more cookies are left into this engine, the more capable will be the engine to profile the need of anyone asking for something on the search engine. And this is something which is not easily replicable by any other newcomer, which will take years, if ever, because time is of the essence. If you spend 2 hours on Google, you don't spend 2 hours on Facebook. You don't spend 2 hours on a new digital platform that no one knows. And this impacts also on the quality of the services, which is, again, a big driver in competition law, because competition should improve quality of the products, of the services. And in fact, think about an example which came to my attention a few days ago. You know, so Twitter or X, whatever you call it, which has been heavily criticized and has been replicated by Mastodon, which is a German invented new, let's say, kind of social network mirroring Twitter or its new denomination. The fact is, Mastodon is considered qualitatively much better than Twitter, does not make a difference. Mastodon is still stuck into 700 million people as users, and will not probably move that because there is shifting costs that you can be the better entity providing this service, but time will be there, but the data will be there, so there will be a very difficult problem to switch to another platform. And this is typical for all these digital market big giants. And we go to the last but one consideration which makes digital markets so interesting, the issue of economy of scope and vertical integration. When you have a zero distribution costs, you can quickly move to adjoining markets without very big problems. Think what Amazon did from selling books to selling everything. The costs of this huge vertical integration was not apparently in any way relevant. And these economies of scope create a phenomenon which is new also from the, let's say, vis-a-vis the old antitrust or physical market story, namely that you have a sort of attraction between your users and customers and competitors. Because as soon as you move and enlarge quickly the scope of your activity into upside or downsides markets, those people who were your, let's say, customers become quickly your competitors. Think about the case decided by the Italian antitrust on Amazon and the distribution chain. So those people were happy to work with Amazon because it was going to bring a lot of opportunities to deliver products physically, and eventually Amazon took this market as well and started imposing its quality conditions and probably its own direct retail and logistics activity. So this is something which is again not new to the antitrust, let's say, story, because vertical integration is typical of any antitrust concern. But in our digital markets, it is easier and absolutely more much quicker. In this market, therefore, we have inflating services, and if you become so powerful in very many markets are joining to each other, where will the competition take place? Possibly, it will not be even possible to think about traditional way of considering exploitative behaviors into adjoining markets, in the sense that there won't be any true competitions in those services, but there will be the need for the dominant or super dominant firms to offer these services, and this service will be welcome for the consumer. The last example I want to make, think about Amazon Prime. Amazon Prime is, with all respect, qualitatively not comparable to other platforms for videos or movies or sports or whatever. But it is so easy for an Amazon client also to switch to that in fact there will be no more competition again on quality, who is the better on that, because if you don't have the whole ecosystem with you, it will be more difficult for people to lose this one-stop shop opportunity, which is absolutely a payoff for consumers. This brings to the classical outcome of these markets, namely that the markets tend to tip. So there is the, let's say, winner takes all. We have over 90% of market shares in different core areas in which the big five compete. And even though this is not, again, an unprecedented story, and even though these market tippings have been reversed in history, I quote, maybe some of you remember, not the younger, but those in my age, if you remember the video cassettes between Betamax and VHS, VHS was much less interesting, but nevertheless, it could conquer the Betamax system, which was standard, which was absolutely dominant, and in a few years, it simply disappeared. But now, and this, I have many examples to which I can tell you about how tipping markets have been moved. There is also one concerning Google, which was, if you remember, not the first mover in these search engines. Alta Vista was actually the dominant firm, and in a few years it just disappeared. But the fact is that in the past 15 years, this reversal of tipping markets seems not to take place. And in fact, we see that the market strength of these entities is growing more and more. So eventually, what can we say as antitrust lovers in respect of digital markets? I fear that we should start thinking differently about categories of law that have been with us for decades, for more than a century, because these categories of law do not satisfy us, I would say. Not to say, again, that we are losing fundamental rights, that the economy is going to be bad. So the old recipes for which antitrust was founded and the principles on which antitrust are based are not cast into disruption because of the evolution of the digital markets. Simply, these firms and these markets put new questions to the citizen, to the policymaker, to the legal scholar, whether tools are fit or unfit for coping with this phenomenon. This is not new in our society. I would like to say that climate change imposes us to think quite differently about law. Artificial intelligence will do the same, and please always remember that artificial intelligence providers, and now we have three big players, ChatGPT, Bing, and Bard, are all of them belonging somehow to the big five. So once again, what will happen of this huge concentration of market power, no one knows. The approach is an ex ante control. Ex post antitrust seem to be not fit for the purpose, if I have to be very frank. Not because it is always slower than the pace of evolution of this market, which is a fact, by the way, but because actually, if you consider what happens then in courts in respect to the public enforcement made by the antitrust authority, if you reason only on the traditional antitrust logics, you may be failing in courts as an antitrust enforcement authority because the reasoning somehow is flawed. Thank you very much.
Thank you. Thank you very much for this brilliant presentation. I think that from your speech, a lot of questions and curiosity and issues could arise. And I hope that the following reports from our other speakers will study in depth some of these issues. Now, my task, I'm very happy to introduce to you the second speaker. What happened? Okay, I can go. Okay, the following speaker, Laura Zoboli. Laura is an assistant professor of commercial law at the University of Brescia and serves as the scientific coordinator of the Center for Antitrust and Regulatory Studies at the University of Warsaw, where she began her tenure. Laura also is an adjunct professor at Bocconi University, where she earned her PhD in legal study. Among her experience, Laura was a Marie Curie Fellow at the University of Turin and a visiting research fellow at the Max Planck Institute for Innovation and Competition. Laura, this is the most important experience in her career, has served as a clerk at the Competition and IP Specialized Court in Milan, from whom I was president in that period, and I had the opportunity to know better Laura during that period. She's brilliant, very clever, and also very, very nice. Laura, the floor is yours. Laura will present the report on market power and market definition in the digital economy. Thank you, Laura.
Thank you, President Tavassi. I'm very happy to be here with you. I want to thank the organizer, and I'm especially happy to be introduced by Dr. Tavassi, who is, let's say, an extremely a protagonist in my antitrust law path. So I guess I'm here thanks to Dr. Tavassi. So I think Professor Munari did a big part of the job, so I'm very happy to rely on many of the points he raised. In particular, I've been asked to speak about market power and market definition in the digital economy, but I think in the end, I will focus on data mainly. So why I will speak only about market power, and I will keep market definition as a background concept. So as we all know, market definition is the starting point of every competition law decision. And of course, in identifying the market, the relevant market, we need to focus on the products and services and on the geographic definition of the market. In doing so, what we do is to use, after we define the market, proxies, which are market shares, to define the market power of a specific company. So this is just to say that anytime we discuss what is the definition of market power in the digital economy, in the data economy, of course, we should start by defining the relevant market, which is not an easy task if we think about the digital markets, because, of course, many of the precedents we have address different markets. And as I was discussing also with Adam Scott, many of the cases we currently have start from the end. So they define the conduct and then they go back and they define the market. So this is just to say that the starting point I want to keep into consideration is that we need to assess significant market power, meaning that a company should be able to keep prices higher, let's say significantly above the competitive level for a sustained period of time without losing economic profits. This is to say that this is a very basic definition, and of course we cannot rely only on price. We should consider all the other variables, from quality to innovation, so on and so forth. So this is just to explain why I will discuss market power. And the second, I can speak. Posso parlare più piano?
Can you close the microphone if you are outside the central bench? Thank you.
So the second premise I want to do is that, of course,
non si preoccupi, non lo tengo,
Era romano più che inglese.
When we discuss about drivers that contribute to market power in the digital sector, we can identify many categories that Professor Munari already discussed much more in detail that I was planning to do, and actually we rely on what he said. I will take advantage of his brilliant overview. Just to say that there are, of course, many different elements that can have an impact on market power in the digital sector, that can make the assessment of market power in the digital sector somehow partially different to the assessment of market power in traditional markets. And one of the many elements that can contribute to market power in the digital sector is, of course, data. So my plan at the end of the day is to focus on market power and data for this presentation, also considering the time I have. And the reason why I selected data is that, of course, there are many different features of, let's say, digital market that can jeopardize conventional, traditional methods of measuring market powers. And among them, in my opinion, data is a protagonist. For many reasons, among them, I identified two main reasons. One of them is that, of course, we are in front of more and more data-driven companies, so business model based on data. And the second one is that when we move in two-sided markets, in the majority of cases, as Professor Munari already stressed, we are in front of a zero-price scheme that, of course, per definition, is, let's say, raising new challenges to the market definition and to the market power determination. The two main issues we need to discuss is, one, if holding data is providing the data holder with market power, and if so, at what condition, and second, if the data-driven business model require to change or at least raise challenges to the conventional methods employed as of today to measure market power in antitrust analysis. So one additional premise that I want to do is that, of course, when we discuss about defining market in the data economy, we should remember that the relevant market is the one where the data are actually used. In other words, if I am, let's say, collecting data that then are used to develop services, products in various markets, of course, the company that is reusing the data can be dominant in the secondary market where it uses the data per se. So, a few more premises, but also in this case, I will go quite fast because Professor Munari in his introductory remarks already mentioned that when we discuss about data, we are discussing about a very specific asset, which is very peculiar in its nature. A comparison that I like to use just to demonstrate how peculiar our data is, we all know that data has been defined also by newspaper as the new oil of our economy. I mean, for many reasons, I consider this definition not to be a correct one, but there is one element in the definition that, in my opinion, is very important, which is that we can find data in the framework in which we operate, as much as oil can be found in the earth. This is just to say that the availability of data is a key element that distinguishes data from every other asset. So data usually can be found in several sources. Very often users, for example, give the same information, the same data to many providers, to many services, so on and so forth. This is just to say that one element that might mitigate market power is the availability, ubiquity of data. Of course, this is just a general premise. And second is that sometimes the volume and variety of data, which is actually what is composing with velocity and all the, let's say, characteristics that we can link to big data, can be relevant, but they are not always needed to assess a possible market power. This is to move to the focus of my presentation, which is understanding what is the actual role of data in market power. Starting from what is...
Per favore, da remoto, chiudete i microfoni.
Ah sì, forse posso
Ce ne siamo
chiuderlo io.
occupati un pochettino, eh?
Qui, vero?
Sì, sì.
Ciao, come stai? Bene, benissimo, grazie.
Mi preparo, solito l'udienza
sì,
importante da
Ragusa. Non dirlo.
settimane.
Io avrei fatto... Non sappiamo chi fosse, non sappiamo chi fosse. Potrebbe essere un altro Mario Siragusa. Okay, so what I want to add, the question I will try to address in the next few minutes is if we can find what is a significant correlation between a company's market power and its possession of big data. Okay, I'm relying on, let's say, many of the categories that Professor Munari already mentioned, just to move in the direction of the method I try to use, namely reconstructing the data value chain, distinguishing each element of the data value chain as a distinct market, and checking if and how, generally speaking, we can detect a correlation between market and power and data. I will do a premise that is not needed, consider that you are all antitrust lawyer, which is, of course, this is just a theoretical exercise. Market power should be assessed on a case-by-case basis. I mean, of course, I cannot tell you if, in the end of the day, a decision will confirm this assessment. It's just an exercise to understand if the correlation is potentially possible or if it should be excluded. And of course, then a case-by-case analysis is needed, depending on the market we discuss, the players, the barriers to entry, so on, so forth. So, what do I mean with data value chain? I distinguish for simplification. In the paper, I will address, let's say, a more broader value chain. For the purpose of this presentation, I selected three main phases. The first one is the phase of data generation and collection, which we can consider the upstream market where players, companies, firms are demanding data. I do need data. I can generate them or I can collect them. And of course, with collect them, we can consider about the model analyzed by Professor Munari, so a platform that is collecting data from users, but we can even consider a company that is actually buying data from third players, so on and so forth. So the modalities that are used to generate and collect data are manifold. The premise, the factual premise, which is commonly recognized as correct, is that data are generally considered an affordable asset. What do I mean? Is that there are many various tools and methods for collecting information. So we can use web scraping tool, we can use algorithms, we can use loyalty programs to convince users to give us information. We can use even analysis of the market. We can just check everything that is online, or we can buy data set by third players. So this is just to say that generally speaking, it is considered as an affordable, let's say, asset. And second, that the sources for data, both in the physical but mainly in the digital world, are manifold in the sense that very often, let's say, they can be easily substituted. So this is just to say that the same event can be recorded by many sources. So again, just to say that the data sources are many. Combining the relatively low cost of acquiring data and the multitude of data sources is usually defined as something that is kind of moving in the direction of not considering a strict connection between the possession of big data, the sole possession of big data, and let's say a specific market power. A peculiarity that should be remembered, in my opinion, is that the market for data generation and collection is also very difficult to be addressed from a competition law perspective, since in this specific case we can certainly find demand side. However, we discuss about an asset that is extracted from the web, from the information received the user, as much as oil is extracted by the hearth. So this is just to say that we can find at the demand side a huge amount of businesses, of course, with different data assets, with different value, and therefore assessing a market power that can fall under definition of significant market power is commonly recognized as extremely rare. So again, going back to the premise of my discussion, we need to go to an assessment on a case-by-case basis, but looking at the data generation and collection, we can perceive two main peculiarities. The first one is that the definition of the market is extremely difficult because we are in front of something that is extracted from the web and then given on the market, so we don't have the two sides very often. And the second peculiarity is that the, let's say, intrinsic nature of data is making them ubiquitous and, let's say, usually a easily joinable asset, even though, of course, we can find many cases in which a specific data set per se is important. But this is something we should discuss in the other two parts of the value chain. In other words, if we think about only the market for collecting the data, it is extremely difficult to define, to identify something that can be so strong to give a data controller market power. So once you generate and collect the data, you can decide to use them or to create new products or ameliorate existing products and services. So you can use the data as an input, or of course, you can even decide to sell the data as a commodity. Of course, one of the two actions that do not exclude the other. So I can decide to diversify my downstream markets. In the case of the supply side, when it comes to defining the market, the task is much more easy because in this case, we do have, let's say, a market in which data are used. Let's imagine that I'm using the data to become the best food provider in the area of Milan, my relevant market. will be quite easily defined. But still there are a few complexities. Why? Because even though, again, we should go on a case-by-case basis, it's extremely difficult to apply the traditional category related to market power and a resource as an input. I mean, I can discuss all of them. I will just give you a few, so we can discuss about the indispensability of the resource. We can discuss about objective necessity. If you think about, for example, the category that everyone discussed when it comes to data as an input, essential facility doctrine, for example, in this specific case, it's extremely difficult to, let's say, fulfill the necessary conditions, in particular if you think about the necessity to demonstrate that the access of a resource is indispensable without knowing what it actually is in the data set you want to access. So when it comes to data used as an input, we can still confirm that the characteristic of the data as an asset are making data, let's say, something that most likely can be obtained from other sources. And second, if we want to apply, let's say, the categories of competition law linked to the essentiality of an input, it is extremely difficult to fulfill the requirements of the essential facility doctrine. If you think about, for example, the new product requirement, this is extremely problematic. It's extremely difficult to demonstrate ex ante without knowing what is in this data set that you need this data to develop your product, to develop your services. And this is actually something that I think we can take for granted and was also confirmed by the European Commission in the competition policy for the digital era communication, where the Commission established that the classical essential facility doctrine may not be the right framework to handle the refusal of access to data cases, as the doctrine has been developed with a view to access classical infrastructure. Of course, the essential facility doctrine, we all know, was developed by the case law, thinking about traditional assets. I need to, connect with the energy infrastructure. They're refusing me the access to the energy infrastructure. I'm invoking the essential facility doctrine. This is just to say that even in the case of data used as an input, it's extremely difficult to find scenarios in which the data holder are actually, let's say, preventing and are exerting a substantial market power. The second downstream market I decided to comment today is the one of data traded as commodities. So after generating and collecting the data, a company decides to sell it to another company, or in a raw or in aggregated form. So we are in front of what we define as a commercialization of data. In this case, I guess that defining the market is something that is more easy. Why? Because the product is actually data. So we are no more in front of the scenarios defining which we should check how the data are used, and therefore data are just one of the many components of the power of the company. But in this case, data is the commodity. Data brokers play the role of the supplier, and we have companies that want to buy this information, this data. In this case, if we can imagine a company that is actually controlling the majority or that has a market power linked to having a volume of data that is so high that, let's say, nobody, the possession of data is giving them substantive market power, then in this case, we can argue that there is some sort of correlation between holding data and market power. Of course, we need to remember that market, let's say, market shares, so should be considered together with many other factors. For example, the level of competitive pressure by potential rivals, the bargaining power of demand, so on and so forth. So this is just one, again, of the many elements, but this is just to say that if we think about data traded as commodity, this is, in my opinion, the sole scenario in which we can find some sort of relationship between the possession of data and the market power, again, to be verified on a case-by-case basis ex post. And again, making it clear that we need to consider also all the other factors used to assess the dominance, and after that, the possible abuse of dominance. Again, borrowing from Professor Munari's presentation, another linked topic is, can we consider then data as a barrier to entry? I think that the case of a multi-sided platform or zero prices platform is helping us in answering to this question. What I mean is that when we discuss about platforms, multi-sided platforms, we're in front of a business model that is per definition data-driven, and many authors argue that the significance of data in these systems clearly have an impact on the market power of multi-sided platforms. So I think if we look at the literature, at the doctrine, this is for sure the more controversial issue when we discuss about market power and data-driven business model. We can distinguish different multi-sided platforms. For simplicity, I will distinguish them in two main categories: those that provide goods and services for free in the market, and like Meta and all these platforms, and those that ask for a price like Uber and so on and so forth. This distinction is needed. Why? Because when we discuss about zero prices platform, we have even a higher level of difficulty, considering that market definition is controversial. It's something that open a quite vibrant debate that I think we can all agree that the case law kind of define. But what I want to stress is that in the case of platform, of multi-sided platform, we have several effects that can be perceived as red flags of market power. What do I mean? I mean, of course, when we look at the multi-sided platforms, the information they collect are then used to personalize services, to offer go toward price discrimination. They are used also to exacerbate lock-in effects. For example, at the end of the day, the switching costs are extremely high, because if I'm used to a specific platform that already know everything I like, most likely I will be more reluctant to leave and go to a competitor. But even more so, the multi-homing service that can be perceived as something that is kind of favoring competition is maybe going in the opposite direction, because I will find myself locked in a ecosystem. So this is just to say, going to the conclusion, that when it comes to multi-sided platform, in my opinion, the real concern is that data, the fact that a specific platform is collecting and, let's say, reusing big data, a huge amount of data, can actually be a barrier to entry to the specific market. Why? Because having control to big data reinforces the position of the platform, which already for its own nature, as is quickly shown in this slide, is let's say, reinforcing what is a business model that is characterized by lock-in effects and increase in switching cost. So just to conclude extremely quickly, in my opinion, we can not find, of course, a correlation between data and market power. Data is one of the many drivers that can be considered when assessing market power and determining if a company has a significant market power. But there are scenarios, like the case of multi-sided platforms, where, of course, data can play an important role in antitrust analysis, in my opinion, more as a barrier to entry than as a driver for market power. Thank you.
Thank you, Laura. Congratulations on your speech. Very interesting, very brilliant presentation. I think that the examine of the examination of the topics of today could be very well concluded by Ginevra Bruzzone. Ginevra is one of the most important experts in Italy in this field, and I think that she can introduce her topic in a very interesting manner. Ginevra teaches internal market and European competition law at the Master in European Economic Governance at Lewis University in Rome. She is Director General of the National Recovery and Resilience Plan Task Force of the Italian Presidency of the Council of Ministers. Ginevra, we are ready to hear you. The door is yours.
Many thanks, Marina. I have the task to discuss the relationship between the ex post approach of EU competition law and the ex-ante rules of the Digital Markets Act, Regulation 1925 of 2022. And I will proceed in two steps. First of all, I will try to compare the rules. Article 102 on one hand, and articles from 5 to 7 of the DMA on the other. Then I will try to discuss the challenges for enforcement, for public and private enforcement, resulting from the coexistence of the two sets of rules, ex-ante rules and ex-post rules. I will start with a short introduction to the DMA. You know that the DMA establishes a list of obligations of do's and don'ts on those undertakings which are designated as digital gatekeepers. And these rules have been introduced as a complement to the traditional EU competition law, especially as a complement to Article 102, which prohibits the abuse of dominant position. If you look at the objectives of the DMA, which are ensuring fairness and contestability in digital markets, they're not really so different from the objectives of competition law and of Article 102. If you think of exclusionary abuses, the objective is maintaining effective competition. So the idea of contestability is there, whereas for exploitative abuses, the objective is to prevent an unfair exploitation of market power. So the idea of fairness is already there. So the objectives are not so different. What is different are the tools, because it is often said that Article 102 follows an ex-post approach, because you can prohibit the abuse of dominance once a dominant undertaking has adopted a conduct which can be considered abusive in light of the case law of the Court of Justice. In the DMA, we have ex-ante rules, rules which are directly applicable to all undertakings which are designated as digital gatekeepers. It does not matter whether they have adopted or not a conduct. The rules, the obligations, the do's and don'ts apply ex-ante to all companies designated as digital gatekeepers for the so-called core platform services. So being an ex-ante set of rules, the DMA is meant to be a more rapid ex-ante tool aimed at preventing undesirable market developments in the digital sector. This is the idea. Now we can try to compare the two sets of rules. Let us start from the scope of application. The precondition for the application of Article 102 is the assessment of dominance. You can apply Article 102 only if you have a dominant company. So you have to address the issue of market definition, the issue of market power. If you look at the DMA rules, it is not necessary to assess market power. Once an undertaking has been designated as a digital gatekeeper for the specific core platform service among a list of core platform services included in the regulation, then you apply the rules. And the way in which a company is designated as digital gatekeeper is mainly based on a set of quantitative indicators, on presumptions based on quantitative indicators. So it is much easier compared to the assessment of dominance. And this is the difference in the scope of application and the preconditions for the application of the rules. If we look at the boundaries of legitimate conduct under the two sets of rules, what happens for Article 102? We have a broad definition of the abuse of dominance is prohibited, so a very broad approach, and a non-exhaustive list of potentially abusive conduct. And we know from the case law of the Court of Justice which are the criteria we should use in order to assess whether a conduct is abusive or not. So for exclusionary abuses, we have to look at the actual or potential impact on market variables, price, quality, variety, innovation, on the basis of a theory of harm. For exploitative abuses, the Court of Justice gives us some criteria in order to assess whether a conduct can be considered abusive in a number of judgments. So we have specific criteria which help us to apply this broad notion of abuse of dominance. And the role of the theory of harm is extremely important, and we have to apply all these criteria on a case-by-case basis. What happens with the rules of the DMA? In this case, we don't have a broad notion. We have an exhaustive list of rules. And once an undertaking has been designated as gatekeeper for a specific core platform service, it has to apply all these do's and don'ts. And so is it so easy to apply the DMA or not? They are meant not to be broad standards, but quite detailed rules. But if you look, I haven't time to look at each individual rule, but if you look at them, they are certainly not mechanical rules. There is still room for interpretation. Article 5 is more self-explanatory. Article 6 and 7, you have more room to discuss what is really necessary to comply with the rule. But in all cases, there is still room for interpretation. For instance, how should I interpret? You should ensure interoperability. You should provide advertisers information on a daily basis. So for every rule of conduct, there is some room for interpretation. And in the DMA, we find a specific procedure whereby, Article 8 of the DMA, whereby the company for Article 6 and 7 may open a discussion, an interaction with the Commission in order to decide to discuss together how the company should comply with these rules. It is for the company to establish how it will comply with the rules, to establish a kind of code of conduct. But there is this possibility to discuss with the Commission. And if the Commission does not agree, the Commission may adopt a specification decision. So there is a kind of dialogue between the company and the Commission. And what are the criteria from a legal viewpoint which have to be used in this discussion? There is no need to assess the impact on the market. The approach is different. A case-by-case assessment of the impact on the conduct on the market is expressly ruled out. What matters is an assessment of the objectives, fairness and contestability, and an assessment of the proportionality of what you are imposing on the firm, because the proportionality principle is still there. And so in order for the Commission to assess whether the commitments, the code of conduct proposed by the company is adequate to comply with these rules, the proportionality principle plays a central role. And the procedure plays a central role in order to find the proper solution, to identify clearly what compliance with each rule of conduct implies in practice for the company. And another important difference between Article 102 and the rules of the DMA concerns the room for justifications, for defenses. You know that for Article 102, the Court of Justice accepts both objective justifications and recently also efficiency defenses on the model of Article 101, paragraph 3 of the treaty. And for the DMA, there is no room for this kind of balancing between efficiency and the objectives of the rules. So there is no room for efficiency defenses. There is only a very narrow room for temporary exceptions if the company runs out of business or for exemptions on grounds of public health and public security, but a really narrow room for exceptions, no room for efficiency defenses. Question, is there still some room for objective justifications in the DMA? It is not written in the DMA, but I suggest that there should be some room for objective justifications, not as an exception, because exceptions are not allowed, but as a consequence of the application of the proportionality principles in the assessment of the legitimate conduct. So when establishing the boundaries of the legitimate conduct, you apply the proportionality principle, and this, in my view, but is my personal view, implies that there may be some room for an objective justification even in the DMA. Then I will shift to the second part of my speech, which is which deals with what are the challenges for enforcement resulting from the coexistence of these two sets of rules. On one hand, Article 102, and on the other, the rules of the DMA. And we must be aware that the rules of the DMA are not yet operational, because they will become fully operational 6 months after the designation of digital gatekeepers. Digital gatekeepers have already been designated, but we are still waiting for the full operation of the rules. When the DMA rules will become operational, there are some areas in which they are not applicable, and there is only room for the application of Article 102, because the DMA applies only to digital gatekeepers. So for companies which are not digital gatekeepers, only the Article 102 remains the tool which we can use. Second, the DMA rules apply only to core platform services of the digital gatekeeper. So for the activities of the digital gatekeeper which are not core platform services, Article 102 remains the only tool. And in the DMA, we have an exhaustive list of rules. And therefore, even for core platform services of digital gatekeepers, there are some aspects which are not regulated by the DMA, for instance, rebates, and therefore there may be room for the application of Article 102 because this is not covered by the DMA. So there is still an area in which Article 102 remains the only tool we can use. But for the other areas, so for the area in which we have a core platform service of a digital gatekeeper, and the conduct is regulated by the DMA, can we also apply Article 102? And first of all, we must consider the case law on the nebis in idem, and if we look at the recent case law of the Court of Justice in B post, we have quite clear guidance on how to approach the issue, because basically in B post, the Court of Justice said that if we look at the idem condition, also in competition law, as in all other areas of law, the scope of protection conferred by Article 50 of the Charter of Fundamental Rights it depends on whether the material facts are identical. So if the material facts are identical, in principle, we are within an idem situation. Then in B post, the Court of Justice says that there may be still room for applying two sets of rules to the same material facts. And they say if provided that the application of the two sets of rules is not based on the same offense or is not in pursuit of the same objectives. So if you can argue that there are different objectives, or at least partially different objectives, the application of competition law and pro-competitive regulation, if we look at the old case law, the traditional case law of the Court of Justice, you may argue, well, in principle, we can apply both sets of rules. But the Court of Justice in B post says that since this is an exception, it should be interpreted narrowly. And this means that if there is a choice between several appropriate measures, recourse must be had to the least onerous one. And you have, you need very clear and predictable rules on which allow you to predict that both sets of rules may be applicable. You must ensure that there is a coordination in the application of the two sets of rules, and at the end, any penalty overall should be proportionate to the offense. So the possibility of the application, contemporary application of the two sets of rules is not completely ruled out, but there are some principles which provide guidance on whether it is sensible or not to apply both sets of rules to the same conduct. And but with in the area of DMA and competition law, we find further indication in the text of the DMA. Because in the text of the DMA, in Article 1, we read that the DMA is without prejudice to the application of Articles 101 and 102, and the national competition rules on agreements and on abuse of dominance, and also of the national competition rules prohibiting other forms of unilateral conduct, national competition rules prohibiting other forms of unilateral conduct insofar as they are applied to undertakings other than gatekeepers or amount to the imposition of further obligations on gatekeepers. This is very important because basically they say the application of the DMA does not rule out the application of 102 or national competition rules. And you remember that if 102 is applicable, you can apply national competition rules only together with Article 102. And it puts a limit on the possibility to apply national competition rules which go beyond Article 102 if these rules are aimed at putting obligations on the gatekeeper which are similar to the obligations provided by the DMA. So basically, they say, if it is a national competition law, as we think of EU competition law 102, the application of the DMA does not exclude the application of Article 102, but national competition rules should not go beyond in order to the DMA in order to regulate the conduct of gatekeepers. And in the DMA, we find also that there is a rule, and we will discuss this in more detail. There are coordination mechanisms, both for public enforcement and for private enforcement. And there is a rule contained in Article 107, which says that national authorities, even in the areas in which in principle you may apply competition rules, shall not take decisions which run counter to a decision adopted by the Commission under the DMA. So if we look, these are the rules on the relationship between the sets of rules. If we look at the rules on the enforcement system, which complement the rules on the relationship between the two sets of rules, what we see that the DMA in both sets of in both areas, both for EU competition law and for the DMA, we find the Commission, the European Commission, which plays a central role. The Commission can use either the DMA or Article 102. We know that for competition law, we have Regulation 1, and so a system, the European Competition Network, a very clear set of coordination mechanisms with the courts, with the national competition authorities, and so on. For the DMA, the role of the Commission is even stronger, because for public enforcement, the Commission is the sole enforcer of the substantive rules. National competition authorities can help, but cannot adopt decisions, either for the designation of the gatekeeper or for saying that a company is infringing the rules. It is only for the Commission to adopt this kind of decisions. And we find, both for court at the level of, national competition authorities cannot adopt decisions based on the DMA. They can only adopt decisions based on competition law. And there are coordination mechanisms in order to avoid problems. And the national courts can apply both the DMA and competition law in principle, because for private enforcement, the DMA does not exclude the direct application of the substantive rules on infringements before a court, but there are still some coordination mechanisms. And at the end, no one can adopt a decision running counter the decision already adopted by the Commission in the same area. So this is quite a complicated system, but if you are familiar with Regulation 1 in the area of competition law, there are many similarities, because for national courts, basically, there is Article 37 of the DMA, which establishes that the Commission and the Member States shall work in close cooperation and coordinate their enforcement actions to ensure a coherent, effective, and complementary enforcement of available legal instruments applied to gatekeepers. So there is an idea of prior coordination of who will go with which tool. And then in Article 38 of the DMA, we find a system which is very similar to the system we find in Regulation 1, in which national competition authorities will have to inform the Commission when they open cases dealing with the gatekeepers on the basis of competition rules. There is an exchange of information, and they should not adopt decisions which run counter to a decision adopted by the Commission in the same area.
And even contemplated. even contemplated the same wording that in
Exactly.
in the regulation number 1.
And for national courts, we have a specific article, Article 39 of the DMA, which is really similar to what we find in Regulation 1. So we have an information system. So if a court does something based on the DMA, similar to what they have to do when they act on the basis of Article 1 or 2, it has to inform the Commission, and the Commission is entitled to give some opinions to the court, either on its own initiative or upon the request of the court. And at the end, there is the rule that Dr. Tavassi mentioned, that the National Court shall not give a decision which runs counter to a decision adopted by the Commission under this regulation, or which would conflict with the decision contemplated by the Commission in this area. So both for Article 102 and for the application of the DMA, we find a similar coordination mechanism aimed to ensure that the system remains consistent. If I have to conclude with the comparison of the two systems, so the rules for coordination, even for national courts, are very similar. But if we look at how the enforcement system is designed, in the DMA, we have a more centralized approach. Why? Because the conduct of digital gatekeepers typically cross borders. And therefore, for public enforcement, you see, the European Commission is the sole enforcer. They decided not to say this also when looking at private enforcement. So in principle, you can have a standalone case concerning the application of the DMA before a national court. But if we look at the subject matter and at the really, I think that the role for standalone actions should be more important for the application of competition law than for the DMA, because for the DMA, there may be some reason for a more centralized enforcement of the substantive rules and the complementary role of the courts concerning the damages actions. So even if in principle, standalone actions are not excluded. So, but the need to discuss with the Commission about the interpretation of is this conduct complying with the DMA obligations. So this kind of dialogue with the Commission, in my view, is even more important for the DMA than in general for the application of EU competition rules. Thanks.
Very well done, Ginevra. Thank you. Thank you to our brilliant speakers of this afternoon. And I believe that these reports suggest further question and issue, but I think that now we have just a few minutes. There are some questions from the audience or on online attendance. No? I don't know if it's possible to check the outside participant.
I don't see any questions.
Any questions? Okay. I think, sorry, we are late. We can conclude our session. No, I think it's his own business. Okay, thank you so much. Thanks again for our speakers, and see you in a few minutes with the second session. Bye. Thank you.
Grazie.
Immagino, è stato sempre un piacere. Adesso corro perché ho un appuntamento e domani mattina ritorno. Ci vediamo a cena, è vero, mi ero già dimenticata. Ci vediamo a cena, ve l'avevo detto? E questa è la cena stasera? No. Sì,
Sì,
è questo?
io ho ricevuto
Ecco, perché siccome avevo
via
due
testa del
conferenze, non
perdono.
vorrei andare a cena alla conferenza sbagliata. Ecco, bene.
Allora, sì,
Spegniamo.
Okay. Good afternoon, everyone. First of all, I'd like to extend my warm appreciation to the organizers of this conference for their dedication and commitment. It is now with great pleasure that I open this distinguished panel to delve deeper into the intricate complexities of EU competition law as applied to the digital market. We are all aware that the technological revolution has indeed ushered in a new era, transforming the way businesses operate and interact with consumers and introducing novel challenges to traditional legal frameworks. Today, we gather to explore the obstacles and nuances related to the application of EU competition policy to the digital economy with a specific focus on the unique challenges connected with governing online platforms under Article 101 and Article 102 of the Treaty on the Functioning of the European Union, but also under the provisions of the Digital Market Act, which are aimed at fostering innovation and enhancing consumer welfare in a context characterized by big tech companies that are quite imperious to economic sanctions. And in this regard, it is crucial to consider, to remember from the outset of our conversation that the EU competition law or the enforcement of EU competition law occurs only ex post. As seen the preceding panel, the digital economy and the data-driven markets have introduced disruptions to key facets of competition law enforcement. This panel will cast a spotlight on specific players and market dynamics, challenging our conventional understanding of EU competition law and examining the intricacies surrounding multi-sided platforms, the role of gatekeepers, and the domain of algorithmic collusion. Without further ado, I am delighted to introduce our esteemed panel, speakers who are at the forefront of legal expertise in the field of EU competition law with a specific reference to the digital sector. Their insights and perspectives will certainly enrich our understanding of the challenges posed by the technological revolution and contribute to the ongoing dialogue on shaping an effective and adaptive competition regulation in the digital era. First of all, we are pleased to have here Daniel Mândrescu, who is a professor of EU competition law at the University of Leiden. He will shed light on the challenges posed by the application of EU competition law to digital infringements, with a specific focus on the abuses of dominance as enacted by multi-sided online platforms. As we know, the digital platform ecosystem has certainly become a cornerstone of our global economy, presenting both opportunities and challenges for legal practitioners and competition authorities. The Commission, upon abandoning an initially passive approach, has given a strong boost to the enforcement of competition law towards big tech companies. Several obligations introduced by the DMA indeed stem from recent competition cases, especially those concerning Google, namely Google AdSense, Google Shopping, and Google Android. Nevertheless, the DMA has a much wider scope than the competition cases that it stems from. As seen before, unlike the competition policy, the DMA is characterized by an ex-ante approach with several specific obligations imposed on gatekeepers. Considering this, the scope of the two legal frameworks must be kept separate in order to prevent the violation of an bis in idem principle and when sanctioning undertakings under both rules. Of course, one must bear in mind that the DMA merely complements rather than replaces the current EU competition rules. This poses the matter of their application when the DMA may not be enforced. It will thus be necessary to grasp the implications of applying Article 102 when faced with a territorial and/or scope expansions of digital platforms, which are intrinsic to their life cycle, with a market market power leveraging being a consequence. Scrutinizing such practices under EU competition law requires careful examination and adjustment in light of their multi-sided nature. Professor Mândrescu will certainly address these and other issues. So thank you very much, and please, you have the floor.
Okay, thank you very much for this well-thought introduction and information on digital economy. And thank you very much for the organizers for their warm invitation to participate in this panel and in this, in a way, special event of which I've never taken part of. I'm usually used to speaking in front of students or other academics. But now it's great that I have the opportunity to actually speak in front of those who have to apply Article 102 to digital platforms, which has been, I can say, my hobby horse or the topic of my PhD and research for the past 8 years. So hopefully today I can give you some information that will help you in the process of applying it when you will be confronted with this issue at your national courts. Now, this topic is very broad, and for today I decided to focus only on issues of discrimination, leveraging, and undefined or newly defined abuses in these contexts, because I think these are topics which you will be confronted with increasingly in practice, especially because the entire enforcement of the DMA will be done at the central level, will be in the hands of the Commission. So most of these cases will come at your doorsteps. And before moving on to this, to these specific issues, I want to first paint a picture of the specific context in which these platforms operate, which you should take into account, and you should consider every time a case actually meets your bench. Because these features, these characteristics of platforms, not only of the markets, but of the actors themselves, will form part, an inseparable part of the legal and economic context, which you have to take into account in that analysis under Article 102. And the first one of these criteria, features, which is relevant, will be relevant in every case, is the manner in which these platforms basically create value. How do they do this? Very simple. They bring about 2 or more separate customer groups on board. They facilitate an interaction between them. And of course, they ask some type of remuneration for it. We all know this story. Why is this important in the context of Article 102? Because every time a case is being brought, the first question that this feature requires you to ask is, are we looking at the entire picture? Are we looking at all the services which are relevant for the question? Are we looking at all the customer groups which are relevant for the case? And are we looking at all the special relationships between these customer groups, which may or may not be covered by the theory of harm in the case? And it sounds simple and it sounds obvious that we should look at all the sides, but Nevertheless, if you look across the existing case law, even though it's limited on multi-sided platforms, a lot of the times the picture is not complete. And that can create problems not only when it comes to identifying harmful behavior, sometimes even, let's say, half-blind assessments can lead to good decisions. That can be the case, for example, in Google Android, or in the case of the Dutch App Store case against Apple. Good decisions, even though they didn't take into account all the parties involved, but that led to poor remedies, because the remedy always needs eventually to be a reflection of that theory of harm which we apply to find an abuse. And if one is incomplete, so will be the other, and the outcome will not be great. And part of this, why this question is important, comes back to the discussion of network effects, which was introduced earlier in the earlier panel. Now, this importance of direct and indirect network effects in the context of platforms is usually discussed as a source of market power. Absolutely true. But what it also does is that it can also work as a vehicle to amplify anti-competitive effects. So if we look at a platform such as Booking.com, for example, let's assume for a second that Booking.com does something which resembles an abusive behavior in order to guarantee that it has control over a disproportionate amount of hotels. Okay. Getting that many hotels on board on Booking.com will, of course, attract more consumers to Booking.com. That's the effect of indirect network effects. More consumers will, of course, again, go back. It will continue to attract more hotels to Booking.com. And so on and so forth will go this snowball of basically amplifying anti-competitive effects, amplifying what was started with one action into perpetuity. So that's why it simply cannot be missed out. Now, in order to get customers on the platform to begin with, what platforms must do is they must rely on skewed pricing schemes, meaning that not every platform customer groups pays the same price to participate on the platform. We consumers usually pay nothing. Hotel owners pay a certain degree on Booking.com. Car rentals pay a certain transaction fee. Airlines pay a certain transaction fee. And the same model applies to any other platform out there. That is not exceptional. That is a necessity for platforms to have. Otherwise, they simply cannot attract different parties to the platform, because different parties have different interests, different needs, different demands from the platform service. But it's also not hard to see how this necessity will trigger, at some point in time, claims of abusive discrimination, perhaps unfair trading conditions. And it's important to keep this in mind, that it is a necessity when assessing whether something is or isn't an abuse. Now, assuming that platform customers make their way eventually to the platform. Under ideal circumstances, these customers will have a choice when it comes to their participation. They can choose between single homing or multi-homing, sticking to one platform to meet their demand for a service versus like booking a hotel room versus using multiple platforms for the same purpose before completing the transaction. Coming back to the context of Article 102, if a behavior is capable, a strategy, no matter what, is capable of preventing platform customers to move from single homing to multi-homing, or discourages it, or pushes, better yet, customers from multi-homing to single homing, what this tells you that the behavior of the concerned platform has in fact succeeded in either sustaining or increasing the market power of the platform in that respective service. Again, not a criteria to be missed. And finally, another reality of platform life or the life cycle is that at some point all platforms expand. Nothing wrong with it. It's inherent to their nature. And it relates to something, it's one of my favorite quotes in technology. I forgot who said it, unfortunately, but it goes like, at the end of the day, everything is a toaster. So at the end of the day, no matter how complex a product is, how advanced a platform is, at some point it becomes boring. So to remain relevant and to remain competitive, platforms also have to expand, both in terms of territories, which is not that harmful in general terms, but more importantly, in the scope of services they offer. Necessity, that's their reality. And at the same time, successful expansions means something quite concerning from the position of competition policy. Successful expansions mean there have been multiple moments in time where market power leveraging has taken place successfully. Was it always anti-competitive? No. Will it always happen? Yes. That is also something that needs to be kept in mind, because at some point in time, all platforms will do this. And at some point in time, an assessment will have to come. When are we dealing with abusive leveraging or not? And from here, we can look a bit closer to matters of discrimination, because like I said, on a multi-sided platforms, not everybody pays the same. And when you look at the platform governance rules, this has yet to be a topic of a case outside the scope of interoperability. Not everybody has the same say in what happens on the platform. Not all developers, for example, app developers, have the same rights and say and development, I would say, input when it comes to the Apple App Store. Some apps are more relevant to Apple than others. So some have more say, some can get away with more things than others. That is, again, an element which is necessary for platforms in order to attract different parties of different importance, of different types, etc. But it is evident that claims of discrimination will at some point come, because no one likes to be treated differently than another entity. When you're a business, you don't like to hear about other colleagues which are treated differently, perhaps better than you. And this is especially the situation with pricing, because that's the most evident moment in time where you can see a difference between you and your peers. And that's also why we see a case in practice, going back now to the Apple App Store, where the first claim of Spotify against Apple saying, well, why should we pay this 30% transaction fee for our subscriptions when Booking.com or Uber, when they complete sales in their apps, they don't have to contribute anything to the Apple App Store? That's simply unreasonable. And this was picked up by the media as a case of discrimination. But this is not discrimination, at least not in the sense of Article 102C, because discrimination in the sense of Article 102 concerns differential treatment for the same service or product between competing entities. Spotify, Booking.com, and Uber, they're not competitors. They're simply all app developers. In that sense, they're equal, but they're not competitors. So any difference in treatment between them is completely irrelevant to the idea of discrimination under Article 102. It's more a question of differentiation, which is a different issue. On top of that, when these claims of discrimination arise, especially in pricing, it's important to realize that there's a difference between anti-competitive discrimination and legitimate discrimination. And that is because discrimination as such, as an act under Article 102, is not prohibited. It only becomes prohibited when there's a sufficient degree of discrimination which creates a competitive disadvantage for the disfavored party. If that's not the case, nothing happens. That is accepted in the case law of the Court of Justice. How much discrimination should be accepted in each case depends on the business model of the platform in each case. And that is because if we look, for example, at let's take, for example, 5% difference in the transaction fees that would be paid on a marketplace platform like Amazon Marketplace. That 5% difference between sellers is much more significant than 5% difference in the fees that would be charged for pay-per-click pay-per-click ads on display advertisement. Why? Because those 5% represent a significantly different proportion of the overall costs of doing business of those actors subject to those fees. So, same difference, entirely different meaning on the overall cost of doing business, therefore an entirely different consequence for a competitive position, or lack of it. And then finally, what do we do with all these cases which are not exactly discrimination and yet we don't like how they look? Turning back to the Apple App Store again. We don't have discrimination. We have differentiation. But we do have an outcome which is perhaps a bit painful in the sense that it just feels a bit wrong. Why? Because if you dive into the figures of the App Store and its financing, it comes down to the fact that approximately 15% of app developers finance the entire App Store for consumers, for other developers, plus a generous profit for Apple, of course, which is very generous because the App Store is about a third of Apple's entire net worth. So that's a lot. And if it's not discrimination, and this is the situation, now you can imagine that app developers would be agreeable to financing this service for consumers because they want to get in touch with them. And the matter of profit to Apple, they will accept because they get very good platforms to access consumers. But they will not be so much interested in financing the App Store service for other developers, even if they don't compete with those developers. So what we have ourselves is a situation which is not discrimination, but it's also a situation where these developers don't want to be. And if that's the case, we may be speaking of a situation where the dominant undertaking, in this case Apple, makes use of an opportunity open to it only by virtue of the fact that it is dominant, that would otherwise not be open to it in a competitive market situation. Otherwise put, we may be dealing with an exploitative abuse. And if that is the case, the best approach to this would be, instead of getting entangled in price discussion of how high should each customer group pay, which would be the wrong approach in my opinion, because that should be left to the platforms as long as we are happy with the end outcome. The approach should be tackling the mechanism which enables this end result to come into being, which is in this case the governance rules of Apple. And this is also how this case is tackled at the European level and also in the Netherlands before the Dutch Competition Authority. And that is the right approach, in my opinion at least. And similar cases will arise. Moving on to leveraging, another issue which is inherent to platforms once they expand, especially in the scope of their services. Here too, in a way, I'm perhaps a bit more positive than the speakers in the previous panel. I think Article 102 can offer quite a bit to tackle leveraging exercises, also issues of discrimination. There is a lot of room for interpretation within these existing frameworks, but when we apply them, it is important that we get a few things well in order to make sure that we simply deviate into cases which do not deserve attention in a way, or are not as harmful as they appear. And the first thing that needs to be done right is where every Article 102 starts, the market definition. Because any case of leveraging from the start requires you to have at least 2 relevant markets. If you don't have 2 relevant markets, you don't have a case of leveraging because there's nothing to leverage in one market. And that might seem evident in situations where expansion takes place over several platforms, like Uber eventually expanded into Uber Eats, 2 separate platforms, 2 separate markets, in a way easy to distinguish. This matter becomes far less clear when you're dealing with expansion on a single platform, like Booking.com, which once upon a time only started with hotel room reservations. Now you can flight search, you can book hotel taxis, and all kinds of other stuff. If we define the relevant market in a case such as in booking, as one OTA market, the entire idea of a leveraging case post-expansion goes away because you don't have more than one market. So that is important to realize at the stage where dominance is being established, how a case is approached. If it's approached in such a way, it ends there because there is no next step. Now, assuming that this is done well and you have yourself a market definition which is suitable for leveraging cases, you want to know, before really diving into the case, how harmful is it likely to be? Is it worth actually researching? And for that, you want to know a few things. One of them is you want to know if this so-called leveraging behavior will have an impact on the choices between single homing and multi-homing. If that's the case, what you also want to know is how and to what extent will the network effects on the platform amplify this effect. That's the second thing. And finally, and that's perhaps one of the more important ones, you want to know what is the actual leveraging potential of the case. If we have ourselves a platform with a 60% market share in the market of its only service it provides, and it expands into another service market, how much of that 60% can it take with it to the next market? Is it the full 60%? Is it part of it or not? And that depends on the nature of the second service which is added. If we talk about complements, for example, they are intended to be used together. So the prospect of leveraging will be perfect, in theory, at least. And that's something you can see, for example, on Booking.com, flight search, hotel reservation. There's a perfect overlap in terms of consumers. Whoever searches a hotel room will likely also search for a flight and vice versa. At the end of it, what you also want to know is how likely it is that the same strategy could also be done by competitors or potential competitors. Because, and again, going back to Booking.com, I don't hate them. I just think they're a very good example because everybody knows them. Going back to Booking.com, it's not only Booking.com that can expand from hotel booking to flight search. It's also websites which are specialized in flight search, which can equally expand into hotel booking reservation, at least in theory. And if that is there in practice, and the likelihood of that happening is quite realistic, then maybe the case in itself is not that harmful. You might result in a market where you have competition between bundles of services rather than standalone services. And if that's something we want and that's how the market evolves, that's a different question for a different panel. But on its own, it might not be as harmful as it seems. Now, despite my positivity about the possibilities within Article 102, there will be cases in the future which concern unprecedented behavior. Things we simply haven't seen before, which don't add up, which don't fit the existing test of Article 102. And yet, when you look at the behavior itself, it goes exactly against what Article 102 tries to prevent, and it creates the competitive harm we try to prevent with this provision. And one of the cases, the recent cases on this is Lithuanian Railways. The removal of a train rail piece as an independent abuse of dominance. Clearly, it's not in the provision, nor should it be. But it goes exactly against what we try to prevent with this provision, and therefore deserves the status of an independent abuse of dominance. The same will happen with platforms. Certain things can simply not be foreseen, but they will go against the rationale of Article 102. And when that happens, it is important that the open-ended character of Article 102 is actually used to identify new forms of abuses and qualify them as such. And as long as the effects-based approach is followed, that shouldn't on its own necessarily be a problem. And when doing it, and this is the last point I will make, it's also important in this process to realize, as well as in the previous discussion on leveraging and discrimination, that the regulatory framework of digital platform keeps on growing. There are more and more and more and more obligations imposed on these actors. Whether it's a good thing or a bad thing, again, for a different panel. But it exists, and it will continue to increase. I think now there are approximately 100 or 200 different regulations in the pipelines, either finished or coming. They will touch upon whatever digital platforms do in some shape or form. And in this process, this will constitute the legal and economic context of these actors, which has to be taken into account. And in certain moments, non-compliance with these frameworks can be used as evidence of anti-competitive behavior or foreclosure. Why? Because certain non-compliance with certain framework will provide entities with a competitive advantage, which is something we want to prevent. That being said, there are no automatic abuses. So there's no, oh, we have an infringement of the DMA, we also have an infringement of Article 102. That's never going to be the case, nor should it be the case. We have the effects-based approach. You have to prove more than non-compliance with a different framework. That's perfectly fine. Also, when compliance on multiple tracks works, as being said, the nebis in idem principle should be complied with. But it is important, even with this growing number of regulation, that Article 102 keeps on being enforced, especially with the DMA in place, which will most likely take the front center stage at the Commission level, that Article 102 keeps on being implemented at the national level, because otherwise, what we will all be missing is private enforcement of Article 102. Compliance with the DMA basically, and this is, again, I'm deviating, but compliance with the DMA for platforms would otherwise create a de facto leniency track for entities if there is later on no enforcement of Article 102. Now, I hope this was an interesting bit for you, and that concludes my presentation. Thank you.
Thank you very much, Daniel, for your interesting speech. Now, we will hear from Jan Blockx, who is a professor at the University of Antwerp, and Professor Jan Blockx will address digital infringements of Article 101, focusing on algorithmic collusion. The anti-competitive risks of algorithms have been at the center of discussions for quite some time now, with digital technologies rapidly replacing human decision-making and commercial operations that are ever more so influenced by computer operating algorithms. Some algorithms are used by undertakings to strengthen anti-competitive agreements that were concluded by humans and are therefore similar to the traditional human forms of collusion. Others, on the contrary, merely serve as tools for human collusion or even have no collusive purpose at all. But they indirectly lead to anti-competitive effects. Sometimes humans lose control of their algorithms that seem to independently agree to collude, raising problems as to their sanctioning under Article 101. Bearing this in mind, the early cases wherein the collusive potential of algorithms has been duly investigated are of great interest. Since then, due to the technological revolution that is currently still taking place, coded algorithms have become more sophisticated and the application of Article 101 far more challenging. The origin of automatic price adjustment algorithms may be traced to the Topkin case, one of the earliest antitrust decisions on the matter. Regarding a collusive price adjustment algorithm used to sell posters, prints, and wall art on Amazon Marketplace. This case, which raised no doubt about its anti-competitive nature, certainly inspired great attention on the matter, requiring careful insights as to its application in the ever-evolving e-commerce markets, and has led to many other cases in the sector. One must question how the relevant provisions may be applied given such a mixed landscape. Maybe Professor Blockx has an answer to this question. Thank you very much.
Thank you very much. I will try to give an answer to these questions. So my presentation is indeed about Article 101, that other article in the antitrust rules, because when we think of digital markets, we talk mostly about Article 102, about the tech giants. Even though, of course, Article 101 was for a very long time really the centerpiece of antitrust enforcement in Europe, the pursuit of cartels. Yeah, it has taken maybe a bit of a backstage position, both because of the increased interest for the tech giants and the practices that they use, as well as some procedural concerns that there is a declining amount of leniency applications and so on. But yeah, there is also, even in the digital world, a role for Article 101. And as I will explain in my presentation, there may be even new types of Article 101 infringements as a result of digital technologies. And so most of these cases are framed around the idea of algorithmic collusion. So to start off with, I should explain what an algorithm is. So an algorithm is a set of instructions, simply. So you could say that a recipe is an algorithm. It says if you want to, it says you get some flours and some milk and some eggs, and you mix it together, and then you can make pancakes, right? Maybe some eggs. So it simply contains steps to perform certain actions and to turn certain inputs, namely the ingredients, into outputs, the pancakes. This is also what computers do, right? Computers, they contain code that describes certain steps that the computers need to perform with inputs to achieve certain outputs. So, and this computerized form of algorithms has, of course, many benefits. That's why we are using digital technology everywhere, and also in the commercial world for businesses. These algorithms, this automated processing of inputs into outputs has many benefits. It allows for prices to be adapted much more quickly in response to changes in demand and supply factors. It allows for prices to be compared, and so on. And so also personalization can take place of products and services, and that avoids the problem that exists in the past, that products were standardized and that consumers had less choice. So many advantages that these tools have, because they're simply much better at processing data large amounts of data than humans are. In addition, computers don't need coffee breaks, they're never sick, they don't need to go on holiday. So also for that reason, there are benefits, and they also have biases, especially if they're trained on human data, but there are certain biases that they do not have. So sometimes said that, I don't know, you know this certainly as judges, that how a judge rules in a case depends on what he or she has eaten for breakfast. That is something that for an algorithm, of course, is not the case. It doesn't need breakfast, and its decisions are not influenced by these kind of factors. But these benefits of the algorithms, they also at the same time allow them to be excellent vehicles for collusion. And that may be contrary to Article 101, the other article, as I said, that prohibits anti-competitive agreements, in particular agreements between competitors in relation to prices, customers, outputs, and so on. And in the literature and in the case law, we can see three main types of categories of practices that have been defined and that I will present to you today, ranging from human collusion that is facilitated by algorithms to autonomous algorithms colluding. So with increasing levels, if you want, of automation and independence of the algorithm. So I will discuss a few cases to show you what the problem is and what kind of practices are have been encountered in the past and why they are considered problematic. All these cases concern pricing practices, so where collusion takes place on prices between competing services. But as such, there is nothing really to prevent the same problem occurring in relation to other competitive parameters than price. You can imagine that algorithms could also collude on what products they offer to consumers. So you might have algorithms that are used by two competing services to recommend different products to different customer groups. That one service provider recommends one type of product to a customer, and another service provider recommends another type of product, so that you have a market sharing agreement that is enforced in this way. But so far, all cases concern pricing, so these are also the cases that I will discuss. The first case was already mentioned, so the Tompkins case. And so this is a case where the algorithm is simply a vehicle of collusion. You have two humans that collude with each other, as in the picture here. One says, I want to engage in price fixing. The other one says, okay, fine, let's do that. And then in order to implement that cartel agreement, they use algorithms. They use digital technology to monitor whether they comply with the agreement, and if they also use tools to automatically set prices, to automatically adjust their prices or their offering in case it's not pricing collusion. So in the Tompkins case, this is what happened. So we had two suppliers of posters on Amazon that agreed that they would charge the same prices, and in order to implement that, they used monitoring and repricing software, and that's also normal. So the posters that were offered by these companies, they have thousands of different types of posters for movies, for pop idols, for different, for maybe Disney figurines and so on. And these have all different prices depending on the license fee that the poster company has to pay to the rights holder, depending on their format and so on. So it would be very difficult to collude on, to fix, to monitor deviations of prices manually, to scroll through Amazon to see that for each of these 1,000 or several thousand posters, the prices are the same. And that is in fact what was tried also in the case of the UK CMA, which followed the Topkins case, which is also about poster collusion. But it didn't work. There were a lot of phone calls, but yeah, in the end, it was too difficult to do this manually. And so the companies used software to do this. They're independently of each other. They did not use the same software. They just, each of them used their own software to monitor the other companies' activities and to adjust their prices to punish, for example, deviations from the collusive outcome or otherwise reset prices if they saw that the other company was complying, for example. So from a legal perspective, I think this poses very little questions, right? You have a collusive agreement, and whether this is implemented by a person that manually resets the prices or manually monitors whether the prices are in line with the collusive agreement, or on the other hand, whether it's done by a tool software that does this, it doesn't really matter. Yeah, whether it's done by a person or by a software, it doesn't matter. And so also the traditional tools for cartel enforcement can be used here. Companies could apply for leniency. There may be whistleblower information. You can do a dawn raid to discover evidence of the original collusive outcome and so on. It may be that, of course, the amount of evidence is reduced. As I said, initially the companies spend a lot of time calling each other to say, well, your poster of Pocahontas was too low, had too low a price, so can you please readjust that? Once the automatic prices system was in place to enforce this agreement, yeah, there was much less need of doing so. The software itself adjusted the prices. And this despite the fact that the price software that was used was different. So in the one case, one of the companies used software that ensured that its price would be set at the same level as that of the competitor. In the other case, the company used software that ensured that its price was the lowest of the market, but it ignored prices of that competitor with whom it had colluded. So as a result, the prices were the same. That is the first simple case. Secondly, it's possible that two companies collude by using the same software, the same digital tools, and that these tools are designed in a way that collusive outcome is reached, or that it facilitates the collusive outcome. A famous case that fits into the first category, I would say, is Eturas. So this was originally a decision of the Competition Council in Lithuania, but it ultimately, there was also a reference for a preliminary ruling from the Court of Justice on this. So there were a number of travel agents that used a system to online book tours for customers, tours to visit sites in Lithuania, and also to offer these tours themselves. And at some point, the company that was offering this platform and that operated the platform send a message to all of the participants that they were going to include a limit on the discounts that could be offered through the system, a limit to 3%. And they implemented changes in the algorithm of this platform to ensure that no one could offer lower discounts than 3%. Yeah, so the collusion, the price fixing, the limitation of discounts in this case was built into the joint software that was used by the companies. There are also other cases, and so in the paper I also discuss other examples of this, but here in this case it's pretty obvious that price fixing takes place because the egregious provision is actually included in the software, although of course it may be difficult if you do not have this email exchange between the companies to discover it, because in the software there will be some code that may have to be interpreted by a human. There's not necessarily or there may be less evidence in human language of what was agreed if it is purely built into the code. But this problem of the joint use of software can also take place in a more subtle way. And here, I think one of the earlier cases is a decision of the former UK competition authority, the OFT, which did an investigation into car insurance brokers more than 10 years ago, where they found that a platform that was used by car insurance providers to give information to brokers so that the brokers could offer the best package of insurance to their customers. This information that was in this database also was made available to the car insurance companies themselves. And they therefore got some visibility on the market. And this was not just information that became available, but the tool also allowed the car insurance providers to do analysis of entire batches of offerings and to reverse engineer thereby the rating models that competitors used. So the information that was exchanged in this way was considered to be too detailed by the OFT, and it allowed the companies to collude on rates. So the companies committed to change the data that was made available, to have it available at a more aggregated level, and also less recent data, so that there was less ability to collude on prices in this way. There are also other cases in this field, pending investigations that I discuss in the paper, where it's not just the information that is made available, but even the software itself that facilitates the collusion. So, in terms of enforcement and detection, this is maybe a bit more complicated, because the fact that you have less communication between the participants in these cases may make it more difficult to discover this form of collusion, unless, of course, the code itself provides that information, but that requires that enforcers, complainants, judges understand what this code means. Yeah? Here, there's not necessarily someone saying, shall we fix prices together, and someone saying yes. On the contrary, there is in the code some ones and zeros or some wording in Python or something else that will need to be interpreted as meaning collusion or not. I will pass over the point of intermediaries. I think in all these cases, the intermediaries were involved in the infringement, so that would be a concern, of course. Finally, what if algorithms themselves collude without intervention of humans? And that is the of course, the most difficult situation. Algorithms, you could have companies using two different algorithms, not the same software, but different software. And somehow this software could learn that it may be better to align itself with the prices of competitors, so of other software. And all of these different applications could learn this and achieve a collusive outcome. Reinforcement learning algorithms, so algorithms that adapt themselves to changing environments on which, of course, technological developments are going very fast, could be used to do this, at least if the data is synthesized, if the data is available. You would need to provide the algorithm with the relevant data. Maybe the weather has an impact on prices, so then weather data would also need to be included in the data, or is the pricing just based on the pricing of competitors, on the cost of inputs? All the data would need to be available for the algorithm in order to set prices. But more and more that is the case, or more and more data is available. And so through trial and error, by setting prices at a certain level, maybe algorithms would learn that it is better if they are programmed to pursue profit maximization, to set prices at the same level or higher than those of competitors, or to learn tit-for-tat strategies where they punish deviations, lower prices of competitors, and so on. There are no cases, as far as I know, of this, but there is some experimental evidence and also some empirical evidence that this may already be happening. There is, for example, the paper that I mentioned on the slides, where some economists analyzed petrol station pricing in Germany, because they learned that more and more pricing in petrol station is done on the basis of AI tools. So there's a lot of pricing data available in the market on wholesale prices, on retail prices of petrol. And the researchers identified the use of these prices by petrol station on the basis of a number of measures. For example, if they noticed that petrol stations were suddenly started changing their prices more regularly and more rapidly, they said that might have been an indication that this petrol station had started using AI tools, that the prices are not changed manually anymore, but that this repricing is done by an AI tool. And they discovered that in markets and duopoly markets, so where you had two petrol stations in the same area, that if these factors indicated that both petrol stations were using these AI tools, that indeed resulted in higher petrol prices. So suggesting that somehow these AI tools learned that it is better to set prices higher. From a legal perspective, this is of course much more difficult since Suikerunie, at least in the EU, we know that economic operators have a right to adapt themselves intelligently to market circumstances, including to the prices of others. Tacit collusion is not prohibited by Article 101, only explicit collusion. So if an algorithm learns, presumably human petrol station operators also know that they should not start a price war, and therefore may keep their prices higher than they would if they would be competing vigorously. If an algorithm, if software also somehow learns that the best profit maximizing strategy is to increase prices and to hope for price increases of competitors as well, how are we meant to prevent that? It's not illegal, and even if it would be illegal to somehow tacitly collude, where do we draw the line between what is acceptable and what is not acceptable? Because We cannot expect that, for example, petrol stations set prices completely disregarding prices that are set by other petrol stations. So there are many legal questions here, practical questions, how this kind of conduct could be tackled, to which I do not have an immediate answer. I propose in the paper a few alternative strategies to deal with these cases, but also have to recognize that none of these are perfect. So to conclude, we see that the use of coded algorithms of software provides for new possibilities for collusion, and this is to support collusion by humans or to facilitate collusion between companies through, for example, the use of joint software, where I think the current tools certainly allow for the intervention by either competition authorities or by judges on the basis of complaints, if the relevant evidence is available. In the case of autonomous collusion, yeah, we are at the moment in a new frontier where it seems to be theoretically possible, but we do not yet have a way to tackle this and to fix it. Thank you very much. Happy to answer any questions.
Thank you very much, Professor Jan Blockx, for this brilliant analysis. Finally, we have the pleasure of welcoming Professor Claudio Lombardi from the University of Aberdeen, who will shed light on the responsibilities of gatekeepers. The issue is particularly timely, considering that just recently the European Commission has designated 6 gatekeepers and 22 core platform services, where it thinks that stricter rules should apply. There are now about 3 months until March 6 for said companies to comply. The rules set in the DMA will hopefully translate into a more open ecosystem, additional choice and control of consumers over the services they use, and further opportunities for businesses to develop new services and foster innovation. The Commission must now ensure effective compliance with the DMA, engaging the gatekeepers as to their proposals on the changes they will bring to their services. In this regard, the Commission published in October the necessary template to lay down the compliance report. And in parallel, the Commission has launched 5 new market investigation to assess whether some other platform services could be subject to the DMA. Besides the new, early next year, there may be new services that meet the thresholds, thus new candidates to be designated as gatekeepers and core platform services. Overall, we must eagerly await to observe the first practical implications and results of the DMA, and I would say if and how the gatekeepers may possibly challenge the Commission's decision before General Court. Thank you very much to Professor Claudio Lombardi, and the floor is yours.
Okay, so thank you very much, everyone. Thank you very much for the kind introduction and for inviting me here today to speak. It's really an honor, but it's also a burden, I believe, because I'm the last barrier for you between you and freedom. So in competition, it's quite unusual this, but I'm an exit barrier. So, and I'll try so to make it as painless as possible. And no, I'm kidding. I'll try to be as brief as possible. And also because I have to be honest, most of the heavyweight lifting from the intellectual point of view was already done by Professor Bruzzone, who has already sketched out at least a part of the things that I will have to, that I wanted to consider today. So I will try not to repeat what she has already said, and also because I wouldn't be able to match the standard, so it's pointless. I will try, hopefully, to say something new, especially by the end of this presentation. But so what I wanted to do is to, first of all, to try to understand how we got here, and reminding you of relatively recent history that though is sometimes forgotten, that things have started not long ago. I mean, this is the DMA has been a relatively fast process that we can say started with a report that was commissioned by Commissioner Vestager, in particular the Kremer report, which actually didn't conclude that the DMA was needed. But it cemented the doubt of the Commission that there were problems that couldn't be solved by using traditional antitrust tools, in particular Article 102. And so the Commission proceeded with the 2 impact assessments. And let's remember that the DMA was only one of them. The other one was the NCT, that is more, it was more geared towards the market inquiries in the UK. So in the UK, the CMA has the power to issue decisions based on market inquiries. And eventually they preferred to adopt the first option, which is now today the Digital Markets Act. Now, the Digital Markets Act also aims at protecting markets in a different way, because the aims that very soon started shaping the Digital Market Acts were, I mean, in the Digital Market Acts, we find several objectives that the Act wants to achieve. But at the end of the day, and this is also what I try to say in the paper, at the end of the day, what everybody says that it's actually true, that the 2 main objectives that it wants to achieve are contestability and fairness of these services. So let's see why, though, also we introduce these new concepts and rules. Well, first and foremost, probably I have to remove these, otherwise you won't be able to see it. First and foremost, anyway, there was a need for speed and procedural efficiency, sorry, you will just see. Which was a problem that was addressed multiple times during the drafting of the DMA, which was actually a real problem. It wasn't probably as much as many, especially scholars, but also within the Commission, pretended it to be, because it's true that the average case regarding these big platforms is somewhere around 4 years long, if I'm not mistaken, the average. But this is just because there have been some egregiously long cases that definitely stretch the average. If you take the median, it's a lot shorter, so that we are somewhere around 2 years and something. I didn't do the math properly, but probably my colleagues have a better idea. But we are somewhere in between 2 and 3 years. Still too long in DMA terms, but not as long as we see in these data regarding average length, duration of the 102 proceedings against these companies. However, there were also other issues. So addressing structural problems in markets and preventing further distortions and harms by introducing new remedies. So it's not just about being super fast, but it's also about addressing new problems that Article 102 couldn't solve. All right. So now, how does the DMA go about this? So trying to achieve these objectives? Well, with the introduction of two new concepts, already been mentioned before, that are, though, defined in a singular way. So we don't find a definition of gatekeeper per se, because the concept of gatekeeper is defined in Article 2 via the concept of core platform service. In the sense that a gatekeeper is an undertaking that provides a core platform service, right? So let's try to take a look at what a core platform service is. And here we have a list of core platform services that, as has been said before by Professor Bruzzone, is quite detailed, but still leaves room to a certain amount of interpretation. And this is true both of, for core platform services and obligations as well, especially those that we find in Article 6, but not only. Now, I will not discuss with you this exhaustive list of core platform services because it's actually it's self-evident. So it's online intermediation services, online search engines. But the peculiar thing, not the peculiar, but the interesting thing about the DMA is that it relies a lot on previous legislation of the EU, especially in using these concepts that we find in the core platform services. So we find many of these concepts that have already been used by other pieces of legislation, and so there are many cross references here. And so probably from a legal perspective, we will have to go back and forth from one piece of legislation to the other, but we are accustomed to that. And it's definitely a lot better this than providing brand new definitions, because they might at some point, especially if the law changes, they may either overlap or clash. So it's definitely, but this is an approach that usually is adopted by the European Union. Now, how the designation takes place? Well, the designation is mostly built on qualitative and quantitative thresholds. So we have two qualitative criteria that are in particular that the gatekeeper or aspiring so has a significant impact on the internal market. It provides a core platform services, which is an important gateway for business users and to reach end users, and it enjoys an entrenched and durable position in its operations. These three qualitative criteria are all built on principles that can be found in the impact assessment, and in particular issues and principles, in particular the fact that the durability and the entrenched position, and the fact that they have to be an important gateway for business users. It addresses, and we will see this more by the end, but it addresses the problem of dominance, yes, in the main market of the gatekeeper, but more than that, I believe, especially if this is paired with the specific obligations that we will see in a moment, it addresses the problem of that has been already discussed before, of leveraging, but of dominance in the adjacent markets. We will discuss this in a moment. Anyway, each of these criterion, though, is defined not simply on the basis of the interpretation of these qualitative criterion, but on the basis of specific qualitative standards, qualitative thresholds. So here, the DMA wanted to leave a lot less to the interpretation of the European Commission in particular in the process of designation, and a lot more to the numbers. So it wanted the numbers to speak. These quantitative criteria include total turnover, but also capitalization. So we have 7 billion turnover in the last financial year, or 75 billion capitalization at least. This is a threshold, as well as number of users, in particular active users. There might be a problem, by the way, in calculating the number of active users, I believe, because it's not as straightforward as users, right? So knowing how many people actively use a service is not as such a straightforward exercise as just asking an undertaking to provide numbers about, for example, how many people have submitted a request or subscription to their services, right? It's a completely different thing. So I think that perhaps there will be problems as we go ahead when we don't have anymore we don't have to deal with the most egregious cases of clear-cut core platform services. We might have problems there in the future. However, okay, so, and in the first designation, as it was said before, at the end didn't surprise anyone, apart from probably ByteDance, in particular TikTok, the provider of the core platform service TikTok, who actually wasn't happy with that because they said that they didn't see that coming. They thought that their service wasn't a core platform service, and they didn't actually meet in particular the qualitative criteria. Some other undertakings have successfully done so. So far, challenging their posing challenges on the basis of the qualitative criteria. But anyway, the list of 6 gatekeepers and 22 services didn't really surprise anyone. We are definitely not, we weren't knocked for a 6 by this particular list. Now, do I still have another 10 minutes or so? Yeah. Now, a quick overview of a quick overview of what has happened instead elsewhere in the world. So everyone has decided to adopt a different concept, perhaps because everyone wants to be a regional. So we see, for example, the concept of, again, gatekeeper in Europe, in the European Union, but also Germany, that has just enacted a new reform, a yet new reform of their competition law, introduced in Article 19A the definition of undertakings of paramount significance for competition across markets. We have in Japan instead a similar regulation that is a lot more limited than the DMA, but anyway speaks about specified digital platform providers. In the UK, we have the undertakings with strategic market status. In the US, the new law talks about the covered company as defined by the Open Up Markets Act. In Korea, we have a very peculiar combination of superior bargaining power and provision of intermediary service to define the targeted companies. This is because the South Korean authority enforces a lot more often their superior bargaining power provisions rather than their respective Article 1 or 2. And Brazil, that is still, I think that they still have to approve their new law on DMA-like law, talks about digital platforms with the power to control essential access. Now, all of them, though, use a combination of qualitative and quantitative criteria, following very much in the wake of the DMA. With the exception of Germany, that decided to rely on a qualitative criterion that is relatively to the DMA, quite broadly structured. Now, when it comes instead to the obligations that we find that are imposed on gatekeepers, we've seen the literature that has tried to create taxonomies by defining these different obligations that we find in Article 5, 6, and 7. However, I decided for sake of simplicity to just call them obligations and prohibitions. I will probably change my mind in the future, but so far I decided that it was probably the most straightforward way to go about it. So we see that we have a bunch of self-executing provisions in Article 5, followed by Article 6 and 7 that are containing provisions that are susceptible of being further specified. Now, Article 5 has 6 prohibitions and 3 obligations, at least as far as I could count them. And the 6 prohibitions, for example, include things such as processing personal data, combining personal data, cross-using personal data. But we find also anti-steering and MFN's provisions, whilst the 3 obligations are more about allowing a user and communication, or allowing end user access to user services and provide information to advertisers and publishers, for example. Some of these want to tackle issues that, for example, competition law wasn't able to really solve. Let's take, I can talk about all of them, but I don't think that we have time. For example, the issue of providing information to advertisers and publishers, apparently it was introduced with having in mind the situation of news markets, right? Whereby news providers mostly earn by providing their services for free to readers and monetizing the advertising markets. However, they were never really 100% sure of whether they were getting a fair share of the advertising or the advertising dollars, because the information that they had was always either limited or difficult to interpret. So some of these problems were that's especially that we find in the obligations were problems that couldn't be clearly solved by competition law, and especially as discussed by national antitrust authorities. For example, the news problem was a case, a French Autorité de la Concurrence case. Now, Article 6 instead includes 5 prohibitions, 11 obligations, and I would say also there are 2 rights that that could play more like justifications, actually, or partly so, of the platforms. So among the prohibitions, we find data-free routing, defaults, and self-preferencing, and together with some lock-in provisions. The obligations instead are, again, most built around data, access to data, in particular providing friends access to data, but also uninstallation or installation and interoperability provisions. I would say something more in a moment, and I will be really done in 2 minutes. And then let me discuss the last bit in a couple of slides. So now let's take again a look at the comparative overview of what other countries have done. And they've all pretty much in the same type of provisions. So most of these other jurisdictions address most of the problems that I mentioned before. However, some of these jurisdictions address problems that we don't find in the DMA. So for example, in the DMA, there is no catch-all clause, but we cannot really find it in any other jurisdiction as well either. But for example, in the UK, you have data sandboxes. You also have the use of bargaining codes in the UK. You also have this thing of data trustees, and data retention periods. This is because the UK DMU will have the power to, and not only in the UK, some of these are also present in Germany. But anyway, because in the UK, the DMU, which stands for Digital Markets Unit, will have the power to issue pro-competitive decisions that are based on that specific case. So they end up based also on bargaining codes that can be drafted ad hoc, almost. So that makes the DMU probably more flexible from this perspective. And also for that reason, the type of also remedies that they can impose are slightly more far-reaching from this specific perspective. Now, do gatekeepers have any can pose any justification for the for directions? Well, there is no efficiency defense, as Professor Bruzzone said before, but there are some limitations to the operability of these provisions in Article 5, 6, and 7. In particular, if they pose a danger to the viability of the gatekeeper's operation, Article 9.1, but also we know that general safety nets of rules based on public health and public security. So if the enactment, the remedies would pose any public health or public security concern, and specific security and privacy concerns that we can find instead in Article 6. This was inspired, I believe, by, in particular, the Apple case, where Apple was, if I'm not mistaken, where Apple was expressed exactly these concerns. If we give access to everyone to the platform, there might be a danger to the consumers in terms of lower quality and security of the and privacy of the services that we deliver. So, to go straight to my conclusions, because I believe that I have to conclude here, I believe that one new thing that definitely we see in most of these regulations all over the world is that most of them, either knowingly so or unconsciously, they adopted this knowledge that has been that is now supported by an important amount of empirical evidence about behavioral economics and behavioral science. So, whilst most of the competition law and competition law enforcement of the last 20 years or so was based to a certain extent on neoclassical price theories, wanting that there is a homo economicus that populates markets and is infallible and is always rational. Now we know that, and actually it seems that we have, with this empirical evidence, it seems that we have reinvented the wheel, but we are just discovering what was obvious to us, but on a more intuitive level, that we actually have bounded willpower, bounded rationality, and that also the laws that shape these markets and that regulate our interactions with platforms that want to take advantage of this bounded rationality and bounded willpower have to probably take this into consideration. And we see this, for example, in some parts of, for example, the anti-steering provisions, but even much more clearly, for example, in Article 6.3, that says that certain terms has to be provided easily, without undue difficulty, and or otherwise to consumers, so that they can uninstall or install apps or exercise their rights otherwise. So these additions, they all try to learn from cases. For example, in the UK, there have been a number of cases that have actually directly applied behavioral economics and behavioral science, but also from the scientific literature. We see, for example, also Article 6.4, among the others, that tries to address the status quo bias of defaults. So all companies know that we are lazy, we love keeping things as they are, and so they give us as first choice, like the pre-tick box of the Planet 49 case, for example, the one that is more beneficial to them, obviously not to us. That's a clear example. Now, these problems will need the coordination with other pieces of, with other regulatory frameworks that we see in Europe, in particular, the DSA and the GDPR. There, especially in the DSA, there is a lot of behavioral science there. However, one may argue that as opposed to the DMA, the DSA took a slightly more paternalistic approach in regulating the interactions between digital platforms and consumers. Want it or not, it can be liberal paternalism at some stage, as some of the proponents of the nudge theory would want to see. Some others may see that instead is too much. But inevitably, the EC, the European Commission, will have a central role in making sure that, I believe, not that really the competition in the core markets of these gatekeepers is possible, but rather in adjacent markets, right? And we would see most likely, from this perspective, further revisions and specifications in the future, especially with, obviously, Article 6, but not only. Okay, so thank you very much, and hopefully it didn't last too long, this one. Thank you. Thank you.
Thank you very much indeed, Professor Lombardi. I guess there is no much time left for at least conclusive remarks, but maybe there are questions from the audience for our speakers.
Yeah, shall I start? Yeah, it's of course. So your question was what about what is the limit between tacit collusion and concerted practice, and is it more likely in some markets than others? It's of course true that in like the petrol station market, there have been allegations of tacit collusion in the past, and so there it may happen more easily. But as if these algorithms indeed are becoming more and more complex and are able to process more and more data, it may be possible for them to also tacitly collude in markets where this was not possible before. So tacit collusion may have always existed, let's say, in a duopoly petrol station market where you have two petrol stations across each other in a road, and they see each other's prices, and if one of them would suddenly drop their prices just below the price of the other one, then the other one will immediately also react by dropping its prices to ensure that the other one doesn't capture the customer. So this has probably existed always, but it may be facilitated because these algorithms are just much quicker at reacting to, or are able to collect more information and much more quicker in reacting. And we may not know, because I do not think that, of course, if you would indeed have a company that says, if in the algorithm or in the code it is programmed in such a way that they always have to follow the price of the other one, then it will obviously be, that could obviously be an indication that there is some collusion happening, even though that is as such, I think, also not illegal. But I don't think the algorithms will be composed like that. They will just say, and the program will just say, you have to maximize profit. So if you earn more profit, you get a reward. And if you get less profit, you have to avoid situations where there is less profit. And then the algorithm is free to experiment through which pricing strategy it will maximize profit, and it will take into account a lot of data like pricing of competitors if that is available on the market, cost, and so on. And it will devise different kind of strategies. And there's also an experimental paper that I did not discuss in the slide, but that is in my paper referred to, where they let these kinds of algorithms run many iterations, different algorithms, so they're not the same, but they just are allowed to experiment a little bit and try different strategies to achieve as profitable pricing as possible. And they also tend to, after millions of iterations, which is of course a lot, tend to also result in higher prices and higher margins. And that is of course how they are sold by the companies that sell this, right? They say, buy our software because we'll give you higher margins. But yeah, they may do that because they realize that, like humans realize, that it's not always good to have a price war, but that it may be better in an oligopolistic market to work together with others. And we, I think, do not, I mean, there has never been a way of tackling this situation, but in the past, this situation may have been more rare than it will be in the future, because these algorithms are able to do this much better than humans are.
What it meant was, in the past, it was the scenario was already there. Like you were in this tacit collusion only when no kind of competition, like from point and so on, where there are not distribution costs and so on. Like the perfect example is the station in a small island, the textbook. If I carry out that business, I find, if I decide to enter that market, I find a situation which may rationally collude. If I decide to instruct my algorithm maximize profit, I'm creating the condition for tacit tacit collusion for which in my view is a different. That was I do agree with what you said.
But it could, for example, also be, and so this is a petrol station market with a homogeneous product, but maybe an algorithm would be able to also engage in tacit collusion for differentiated products because it can take into account so much data.
I mean, why I decide to use the algorithm and creating the market condition with what could be as I view something more than
Because you choose to use an algorithm instead.
only thing that allows us to
Yeah. Yeah, but then the remedy would be to say that in some markets it is not allowed to set prices through software. It has to be done manually. That would also be, I mean, maybe that is something I discuss a few of these alternative solutions. Maybe if we see that there is tacit collusive outcomes in some market, maybe regulatory intervention would say you cannot take into account certain factors to set your prices, or you cannot have certain aspects of your offering be automated. But at the moment, we do not have rules like that. I mean, you can't price manually or you can price automatically. I think it would be difficult to argue. What may be more likely, I think, is if an algorithm decides that it's, for example, interesting, but you would have to find that out in the code, right? If the algorithm decides that it would be good to publish prices earlier than was done in the past, because this would give transparency to other market players, and therefore the other market players would be able to react and collude as well. And so a price signaling kind of situation. Maybe then, as an authority, or if there is a complaint as a judge, you could say, no, you cannot publish these prices in advance anymore because you do this merely to signal to others that you're going to set prices and to invite them to collude. So I can imagine that could be viewed as problematic and that you intervene then. But to prove that will not be obvious, I think. Yeah.
Well, I guess we should wait until we decompile the first algorithm, but always keep in mind that before the Sherman Act, everybody also took for price fixing is both legal and rational. It's still economically rational, mind you, it's just that it's no longer legal. So let's wait. Can we start with a rhetorical question or with a real one? The rhetorical question is that you mentioned twice, Professor Mândrescu, that now we have
of time 20, 30 years back when most abuses were per se abuses, but then return it back in a much more complex arena where the I would say the margin of error is much larger. So I'm I really don't think you can even actually get away from the effect-based approach. This is something which is attempted with the DMA because we have these prescribed obligations, yes, but we also have Article 8 of the DMA, which says when you comply with the DMA, you should do so in a very meaningful way. And how do you assess meaningful? Well, you start looking again at effects. So with all these circling around, whether it's good or bad, I just don't think it goes away.
This is probably not explain why.
Yeah.
Briefly, I think it goes wrong in that it adopts bad rules about location of risk, location of costs. I think that the approach is really precautionary principle. Once you adopt it and you stop thinking in terms of effects based, but rather in terms of impact, and whether this impact is due to the leveraging of the dominant firm's power, which is basically the original antitrust conception that it's illegitimate for you to leverage your power, to your market power in order to further your market interests. Life becomes much simpler, I think. But anyway, and now a really genuine question, please. Which companies argue successfully that they are not gatekeepers? There were no surprises in the list of the companies that are considered gatekeepers. But who was found not to be one? What are the other companies that can be?
Okay, so which one I do first? Okay, so let's go probably chronologically. So DMA and Article 102, I can see that people really need to leave. So I will be very brief. For me, there are informal and formal issues here. So one of the formal ones are addressed already by the DMA, or at least the DMA wish to do so by ensuring both harmonization and complementarity of these two tools. However, as Professor Bruzzone said before, quite persuasively so, I think, the relationship between the two is not as straightforward as the DMA pretends it to be. And it's not just a matter of ne bis in idem, it's also a matter of how these provisions and these obligations are interpreted. But then there is obviously, as you said, Luca, before, there is obviously, there would be inevitably also some, there would be informal dynamics that will allow within the Commission to cross-fertilize concepts, because probably at some point concepts will be borrowed from one side to the other, just like the DMA was born on the basis mostly of EU case law, actually in part also national case law. For example, the Facebook German case inspired quite a few provisions. And probably it will also go the other way around. Some concepts and ideas developed within DMA and for DMA's enforcement will then find their way through Article 102. That being said, then the companies that have arguably that have done so successfully. So I can't remember all of them, to be honest. Maybe my co-panelists they do remember, but definitely Microsoft has done that successfully with some of its core platform services. Then we have Spotify. We've got who else? Samsung. Yeah, Samsung, perfect. And
Google.
Yeah, Google with some of its with some of its services. There was also another Gatekeeper, another undertaking that together with Samsung that is not among the 6 ones. That ByteDance it was included eventually. Anyway, these are the main ones. And as far as I know, they all argued, their main arguments were based on the qualitative criteria rather than on the quantitative, because obviously if you can defeat the qualitative, then yeah. Yes, the core platform service, yeah, because the gatekeeper is defined through the concept of core platform service. So what you have to do is to show that that particular service is not a core platform service because it doesn't fulfill any of the three cumulative criteria plus the respective quantitative criteria. So that's
Objection.
yeah. No, go for that.
Yeah, I do not know. I think ByteDance is contesting it. Apple is also contesting it for some of the services. I think for the iOS. And then there's a third one. Is it Amazon or yeah? I'm not sure, but there are indeed three, I believe, companies that contest all of their designation or part of their designation as a gatekeeper.
Actually, I see a digital hand, so maybe we have to
Unmute? No, I think that they can unmute themselves, right?
Yeah, sure. Yeah.
maybe someone can help us.
My name is Nikas from University of Turin. I have a very, I don't know, a very funny question. Like, I don't know if it's okay for software to set the prices of the commodities that we buy in the market. And if it is yes, that it is okay, then why? I mean, I don't really get it. That's my simple question.
Why should software determine price of commodities and should it be allowed? Yeah, what is not prohibited is allowed. So that I think is the basic answer. So at the moment, it's not prohibited for software to determine prices. And as I said in the beginning of my presentation, there are also many efficiencies in software determining prices. So we could not have an app store, or we could not have Uber, for example, if software didn't determine prices, because they use dynamic prices. So it's on the basis of a lot of data. Advertising prices online are also done in an automated manner, and so on. And it's not only prices, as I said, you can also imagine collusion on non-pricing factors. And so your stream on Facebook is determined on the basis of software, of course. There's not a person that determines what you get next, and so on. So software does a lot of things that make also a lot of sense. So I don't know if that is sufficient as a question, or do you have specific things in mind?
Thank you. Thank you very much. It's very clear. I get it.
Great.
So I think there is no time left. So thank you very much to all the speakers. Thank you to all of you for attending this panel. And once again to the organizers of this conference, Professor Calzolari, Professor Croci, and all the others. Thank you. See you soon.